55 to almost 69. Rights and liabilities of the beneficiary. As such, there is nothing technical to discuss about the rights. But anyway, you may go through on your own. But let take it one by one. Section 55, which talks about the profits. Any profit which is coming from the subject matter of the trust property, the beneficiary has the right to take that profit. So simple. Rights to rents and profits. The beneficiary has, subject to the provisions of the instrument of trust, if there is any condition in the instrument of trust, a right to the rents and profits of the trust property. It is his right to get the rent and if there is any other profit from the trust property given in section 55. 56. Right to specific execution. It is the right of beneficiary. The beneficiary is entitled to have the intention of the author of the trust specifically executed to the extent of the beneficiary's interest. Whatever interest uh, intention has been of the author, that trust must be executed according to that intention. And it is the right of the beneficiary to look into whether that intention is being rightly executed or not. If it is not being executed in that sense, in that manner, it is the right of the beneficiary. The beneficiary can approach to the court and can ask to execute for specific execution. Specific execution means that whatever was given in the instrument of trust or whatever was the intention of the author. And if the trust property is of, if there is any transfer of the subject matter is involved, the second clause of section 56 talks about the right to transfer of possession. Beneficiary has the right to take the possession of that property, and where there is only one beneficiary and is competent to contract, or where there are several beneficiaries and they are competent to contract, all of one mind, he or they may require the trustee to transfer the trust property to him or them. They may ask the trustee to transfer that property. When property has been transferred or bequeathed to the benefits of a married woman, so that she shall not have power to deprive herself to her beneficial interest, nothing in the second clause of this section applies to such property during her marriage. You may have gone through section 14 of the Hindu Succession Act. Before section 14 of Hindu Succession Act, what was the position? The position was that the woman in the property, the married woman in the property, has had the limited right. She has limited interest in the property. It is in that context, if the beneficiary is somehow the married woman, and if it is given that she cannot transfer the property during her marriage, above given condition is not applicable in that case, in the case of married women. But after section 14, it is the position is different. But as we know that these acts are very old act, it is our 1882 act, and there are many. Suppose, for example, if you read the Advocate Act, you will find so many terms. When you will go for the registration, you certainly will read the Advocate Act, or you might read in 10th semester. You will find many terms still are there, which are not in existence these days. For example, the Vakil is still there, and there are many terms you will find in the Advocate Act which have no existence these days. In the same manner, all these acts have not been amended according to the spirit of later amended acts. So it is not so important. It is not applicable these days. Section 57, right to inspect and take copies of instrument of trust or accounts, etc. It is the right of the beneficiary to take the instrument of trust, to look into, to check the accounts and any other paper, etc., any other paper which is related to that trust. The beneficiary has a right as against the trustee and all persons claiming under him with notice of the trust to inspect and take copies of the instrument of trust, the documents of the title relating solely to the trust property, the accounts of the trust property, and the vouchers by which they are supported, and the cases submitted and opinions taken by the trustee for his guidance in the discharge of his duties. You see, there's a very interesting thing in the rights of the beneficiary. The beneficiary has only right to proceed against the trustee. All these rights beneficiary has, but all these rights are against the trustee. What does it mean? It means that if the trustee is not doing something, it is his right, he may make trustee to do that thing. Why it is so? Because the beneficiary actually has no state interest in the subject matter. State means ESTAT, state is with the trustee, not with the beneficiary. So if beneficiary is finding any time that he is not getting something, or he is entitled to a certain thing and is not according to the trust, etc., etc., so what can he do? He can ask the trustee. What can he do? He can go against the trustee in the court. All the rights are available against the trustee. Ultimately, the trustee has to do. Okay. So section 57 simply talks about the inspection of the documents, taking the copy of the instruments, etc., etc. Very simple. Section 58, right to transfer beneficial interest. Benefic- Beneficiary has the right to transfer beneficial interest. And just short while ago I said that the beneficiary has no state. If the beneficiary has no state, how can he transfer? And that lies in this, not the property itself, but the beneficial interest in the property. What do you understand by the beneficial interest? Can you give some example? There are two things. Transfer of property itself. You have a house, and if you are selling that house, that means you are transferring that house to the buyer. But what is the transfer of beneficial interest? There are many examples, and of course, you know. I know that you know. For example, mortgage. It is a transfer of beneficial interest. What happens in mortgage? The possession is given to a person for a certain time, and after that time, it is redeemed. It is for such cases. Section 58, which talks about the right to transfer beneficial interest. It says that the beneficiary, if competent to contract, may transfer his interest, not the property, may transfer his interest, but subject to the law for the time being force as to the circumstances and the extent to which he may dispose of such interest. Right? Provided that when the property is transferred or bequeathed for the benefit of a married woman, again this condition is the same. It is applicable in the case of the married woman, where the married woman is not allowed to transfer her interest. This condition is not applicable in those cases. What does Section 58 say? That the beneficiary has the right to transfer his beneficial interest. Okay. If the beneficiary wants, suppose to give the subject matter, the trust property in mortgage, if the trust is created for his benefit, for the income, for suppose rental income, but if he wants that the rent is not so beneficial as the mortgage will be beneficial, if he intends to give that property in the mortgage, he can. Section 59, right to sue for execution of trust. If the trustee is not executing the trust, or if for any reason there is no trustee, in that case it is the right of the beneficiary for the execution of trust. It says that where no trustees are appointed, or all the trustee die, if there is no trustee is appointed yet, or if the trustees are appointed but trustee or trustees died, disclaim or are discharged from their duties, the trustees are discharged from their duties, or where any other reason the execution of the trust by the trustee is or become impracticable. Obviously, these are the circumstances where the execution of the trust will become impossible. So suppose that the trustee died, how can the trust be executed? It becomes impracticable. The beneficiary may institute a suit for the execution of the trust. It is his right. It is beneficiary's right that he can institute a suit, and the trust so far as may be possible, be executed by the court itself until the appointment of new trustees or trustee. What the court will do after that institution of the suit, the court itself will execute the trust unless the trustees are appointed. If the trustees are appointed, for example, the court may opt to immediately appoint the trustee. The court need not to execute the trust. Section 60, right to proper trustees. What are the proper trustees? The beneficiary has a right that the trust property shall be properly protected and held and administered by proper person and by a proper number of such person. It is his right that the trust property will be administered or managed or will be looked after by a proper person. If it is not being looked after by a proper person, a remedy is available to the beneficiary for proper person can approach to the court for appointing a proper person in place of this improper person. Now, there are two explanations, and these explanations describes about the who are the proper person. Every person is a proper person except who are not proper person given in these explanations. Who are not proper person, number one, if a person is domiciled abroad, a person domiciled abroad is not a proper person. So what happens, suppose if in a trust, after creation of the trustee was appointed, and after some time that trustee has gone abroad. So now he is not a proper person. If he is not a proper person, so it is his right, it is beneficiary right to have a proper person in his place. Second, if a person having any inconsistent interest with the beneficiary, he is also not a proper person. If the trustee has any inconsistent interest with the interest of the beneficiary, that means he is not a proper person for the purpose. Third, suppose if he is insolvent, trustee has become insolvent, he is not a proper person. If trustee is a minor and the situation is like this, where the trustee has to use his discretion, in that case, if he is a minor, he is not a proper person. So, who are not a proper person, they are given in explanation. After section 60, 61 says that right to compel to any act of duty. Compel to whom? Right to compel the trustee to any act of duty. The beneficiary has a right that his trustee shall be compelled to perform any particular act of his duty as such and the restraint from committing any contemplated or probable breach of trust. It is the beneficiary right. What is beneficiary right? Comment. Whatever duties are assigned to the trustee, it is very simple that the trustee has to comply all those duty, has to perform all those duties. If the trustee is not performing the duty, it is his right, it is the beneficiary right that the trustee should go according to his duties. If it does happen that the trustee is not performing his duty, because it is very difficult. There may be a situation that the trustee may be performing duty, but somehow the beneficiary thinks that he is not performing duty accordingly. It is not the matter of discretion of the beneficiary. All of a sudden, the beneficiary will say that the trustee is not performing his duties, therefore he should go. What is the procedure? For that, the beneficiary has to approach to the court. He has to approach to the court for an injunction. If the beneficiary thinks so, that the trustee is not performing his duty or duties, in that case, the beneficiary, it is his right, beneficiary right to approach to the court and he may explain to the court that this trustee is not performing his duty properly. And in response to that, obviously the court will apply its judicial mind, and after that court will decide whether court may give the order for injunction or any other remedy, whatever court thinks proper. Section 62, wrongful purchase by trustee. It is a long section. I'm just explaining the crux of this section. How can there be a wrongful purchase by the trustee? Purchase by the trustee himself of the trust property. It is very much clear that the trustee cannot purchase that property. And we also read in the duties of the trustee. But sometimes there can be a wrongful purchase by the trustee. So what can be the wrongful purchase by the trustee? For example, you must have known about the Benami transaction. Does it exist today? Have you heard about Benami transaction? It does not exist today. It was repealed in 1988. Up to 1988, it was a legal transaction. Benami transaction means where you are actual purchaser of the property, but you are purchasing that property in somebody else's name. A is purchasing property, but in the name of B. Consideration and money is being given by A. Everything belongs to A, but for the sake of name or on paper, there is the name of B. Actual owner is A, and it was widely prevalent at a time, widely prevalent. Even today, it happens in some other uh, way. So what happens? What wrongful purchase by trustee means? Because it is trustee know that he cannot purchase this property because as he is the trustee of this property. So what can he do? He can prepare somebody else, third person, for the sake of his name, and he can purchase that property. And technically there is nothing wrong. Suppose that the trust property is to be sold out. At that sale, the trustee manage all these things, and somehow it is transferred. It is just it is Benami transaction takes place managed by the trustee. Section 62 prohibits such types of purchase. Why section 62 is prohibiting such purchase? Because it was legal at a time. Benami transaction was illegal. This was repealed in 1918. You must have read in the Transfer of Property Act, I know. Okay. So such type of transactions purchase are prohibited. Section 63, the last section, you have to read up to this section with regard to the rights of the beneficiary, not more than that. Where trust property comes into the hands of a third person is inconsistently with the trust, the beneficiary may require him to admit formally or may institute a suit for declaration that the property is comprised in the trust. Now it is very important that suppose the trustee is somehow, this section is not explaining the situation, but somehow if the trust property comes in the wrong hands, either done by the trustee or due to some other circumstances. Because what actually happens in the practice? Where in a trust property, where is the trustee? Everybody knows the trustee. This is the trust property and he is the trustee, and that means everything is to be done by this trustee with regard to this property. Nobody knows about the beneficiary. And suppose if everybody knows about the beneficiary, it doesn't make any difference because the actual administration is in the hands of the trustee. But somehow, for any reason, it goes to the wrong hands. Wrong hands means it goes in the hands of a person who is not a trustee. Now, that is the different question. How it comes in the wrong hands and what is the liability of the trustee in that case? What should be the punishment of or the liability of the trustee? That will remain there. But with respect to the that trust property, what to do right now by the beneficiary? In that case, section 63 allows that the beneficiary, section 63 gives this right to the beneficiary. The beneficiary may approach to the court for the declaratory suit, for the declaration. And I know you know about the declaratory suit, declaration. What is the declaration? In civil court, a suit is filed. There are many circumstances where the declaratory suits are filed. Generally, what happens? The suit is between two parties, A and B. Okay. Suppose there is a suit between A and B with regard to the house property. The court has to decide that who uh, to whom this house belongs. It is a civil right. Okay. But sometime what happens? There is no it's a dispute between with regard to the property. For example, if in your house, if there is a distribution of the property, every property belongs to your father. Now, father wants to distribute that property right now. Suppose a father wants to distribute among his four sons. There are four sons. That division of the property or distribution, arrangement, or settlement, family settlement is known as family settlement, is done by the family. Okay. But it has no legal status. To give it legal status, this matter is brought before the court. This is our family settlement. We have distributed this property in this manner. Kindly declare it. It is known as declaratory suit. Declaration. Okay. So, if such situation arises in the case of beneficiary, trust property, if such thing happens, in that case, the beneficiary can approach to the court for declaratory suit for the declaration. If it comes in the wrong hands, trust property comes in the wrong hands, to require beneficiary may require him to admit formally. That wrong person should admit formally beneficiary, or may institute a suit for the declaration. Right? It was all about the rights of the beneficiary, and now the last section, that is related to the liability of beneficiary. Now, of course, the beneficiary has certain liability, and wherever there are rights, there are liabilities also. What are the liabilities of the beneficiary? Section 68 says where one of the several beneficiaries, there are several beneficiaries, if there is one beneficiary, no issue. If there are several beneficiaries, if they joins in committing breach of trust, if several beneficiaries commits a breach of trust, B knowingly obtains any advantage therefrom without the consent of the other beneficiary. If the some beneficiary obtain the some uh, advantage from the trust property which is not in the knowledge of the other beneficiary, Third, becomes aware of the breach of trust committed. A breach of trust has been already committed in the trust property or intended to be committed, and either actually conceal it. Some breach of trust takes place and the some beneficiary intentionally concealing it or does not within the reasonable time take proper steps to protect the interest of the other beneficiary. Like he has come to know about the breach of trust and he is not acting, he is concealing and he is not acting accordingly, he is not informing about that breach of trust or has deceived the trustee. All the duties are not only of trustee, beneficiary has also the duty that he has deceived the trustee and thereby induced him to commit a breach of trust, where the beneficiary himself is inducing trustee, and it happens to commit a breach of trust, or other beneficiaries are entitled to have all his beneficial interest impounded as against him. His interest will be if above said anything happens, anything, because everywhere there is or. His interest will be impounded as against him and all who claim under him until the loss caused by the breach has been compensated. If any breach has been committed, his interest, whosoever has committed that breach, whosoever induced the trustee to commit the breach, or any of the above thing, his interest will be impounded till that loss is compensated by him. Okay, it was section 68, and again proviso with regarding, you will find this proviso everywhere regarding married women. It was all about the rights and liability of the beneficiary. I think trust is almost completed. Now the fourth schedule. What is the fourth schedule? We will have one or two class maximum on fourth schedule. Okay. Any questions, please? Any question? Anything? There is no reaction from your